Jeffrey Lucas. Jeff is a licensed land surveyor in Alabama, Florida, Georgia, Mississippi, and Tennessee. He is also a licensed attorney in the state of Alabama. Jeff is a recognized expert in land boundary law, riparian rights, and land surveying liability issues. He has practiced land surveying throughout the 5 southeastern states in which he is licensed. Jeff is also an author, columnist, lecturer, and seminar presenter. He has authored 3 books on surveying, of course, one of them tonight being The Pincushion Effect, and has over 100 nationally published articles and over 30 titles in his seminar library. Jeff has presented continuing education seminars at conferences from Alaska to Florida, from California to Nova Scotia, and most places in between. For more information, we can purchase Jeff's book on the Lucas & Company website, find more information on his bio, join his newsletter. There's all kinds of stuff that Jeff's been doing that's great for the profession. And so I truly appreciate your time jumping on tonight. I know you're extremely busy. It follows up the last couple of weeks. Jerry has kind of done the mathematics side of the errors and that kind of stuff and how we end up with the pincushion effect. So it's good to kind of talk about this side of it and what happens after there is a pincushion effect. So we definitely appreciate your time. Thank you, sir.
Well, thanks, Trent. I appreciate the opportunity to be on your program. I'll be honest with you. I thought we were just going to sit around the campfire and talk about the book, but
we could do that afterwards.
I can. I've got. How long are we going? By the way, is this an hour?
Yeah, you can go as long as you want. So typically we kind of keep them at about an hour and a half. So you can chat for an hour, and we can have Q&A for half an hour. So
okay,
whenever you feel like a good breaking point.
All right, that's fine. Yep. The book, I could do a 2-day seminar on the book. So what I'll probably do is just kind of hit the chapter headings and talk about some of the stuff that's in the book. I guess the first thing should be, why did I write the book?
Right. Exactly.
And that would be because I never truly understood what my duties and responsibilities are or were as a land surveyor when I first became a land surveyor. One of the things I have learned over the years is, and this was part of the whole issue, is that land surveying in a lot of ways is practiced as a belief system. It's practiced as what I call survey mythology, which is part of the problem here with the Pincushion Corner. Surveyors just believe they're supposed to do certain things. And I was taught this kind of stuff too when I was early on in my practice, or before I actually was a licensed surveyor, is, there's this belief you're supposed to go out there and break the section down every time you go into a section, although the 2009 manual especially makes that pretty clear that that's not what we're supposed to be doing. If you want to talk about the manual and other things, to be honest with you, when I first became licensed in 1984, I had more questions than I had answers. And of course, just like with the bar exam, they don't, and law school, they don't teach you how to be a practicing attorney. They don't teach you how to be a practicing surveyor. They just teach you about the law. And they, and I guess we're lucky if the programs that we have teach surveyors about surveying, the practice of surveying, but I won't go too far down that little rabbit hole. But so I guess, and I've been a little rough on Brown over the years. I'd say Brown in a general sense, talking about the books that still survive with his name on them, Evidence and Procedures, Boundary Control and Legal Principles. Mr. Brown was actually probably quite a good fellow. I never met him. Our paths never crossed. That would have been the early part of my career and the later part of his career. But I will put a plug in for Michael Palomary's book, The Kurt Brown Chronicles. he and I exchanged books some while back, a couple of 3 years ago, maybe more like 4 or 5 years ago now. And traveling through airports and going to conferences, I spent quite a bit of time in that book, and I came to understand Mr. Brown a little bit better, a lot better, as a matter of fact. And the point of fact is, although he started out as the father of what I call and other people refer to as deed staking. When I say deed staking, that's basically ignoring most of the evidence relative to boundary location, finding a point to start from, and then putting the geometry of the deed on the ground, which is part of what we have here. I think I have some tools, which is part of the deal here. This is the results of this is a result of the surveyor's confusion over our duties and responsibilities towards land boundaries. Why in the world would there be more than one monument in the ground when there's only one corner in legal contemplation? Couple of things going on there. One of them is the only evidence we're looking at, the only evidence we're applying in the field is the geometry from the deed. So that's what I refer to as deed staking. But he admitted in a Brown admitted in a 1979 article that he wrote for the old Surveying and Mapping magazine for the ACSM, the old ACSM, American Congress on Surveying and Mapping, that he started out his career, advising surveyors to basically go stake the deed and then hide behind the client's deed, and that's all you really need to do. So, although he was the father of deed staking, at the very end of his career, after he wrote that article, he became accused of being a fence line surveyor because of the case he was discussing in that article, which was surveyor's liability to unwritten rights. And I won't go too deep into that, other than to say that unwritten rights is it's a term I've used. It's probably in the Pincushion effect book there somewhere. But I've come to realize that term is actually a misnomer. There are no unwritten rights. It's an interpretation issue. Generally speaking, the rights are written. It's interpreting what those rights are. For instance, in a junior-senior rights scenario, the junior is always read in light of the senior, and therefore it's an interpretation issue. And that was the basis of the court case that Mr. Brown was involved in that prompted his 1979 article. I forgot the name of the case. Western Title versus McCormick. I think that was the engineering surveying firm, was McCormick. And it was basically a junior-senior rights issue, and he referred to it as unwritten rights. But I doubt we'll have time to get into that. That could be a whole podcast on its own, just talking about that particular case and Mr. Brown. But all that said, so one of the reasons for writing this book is I was thinking about this right after I got licensed. Why? And I was licensed down in Florida first, and that's sectionalized land, and it's flat land. So all of the roads are running down the section lines. And so if you want to go to a section corner, that's generally an intersection, unless there's a swamp or some other thing that prevented them from taking the roads right down the section lines. And you would go to out into the intersection, and invariably you would find multiple monuments, a couple of railroad spikes, a patch in the road. You pull the patch up and there's a couple of pipes underneath the pavement. Then there was various and sundry PK nails, nails and washers, PKs and washers. I mean, you could find a dozen or so in some situations, monuments in the intersection, all representing one section corner in legal contemplation. So what in the heck, what's going on here? Why are we doing this? And why am I doing it? I mean, that's what I was taught to do. Matter of fact, I think on my first exam, there was a question, a test question on how to break a section down. And what a useless question. I mean, in today's day and age, I mean, when am I ever going to be in a situation where in private practice, at least where I practice, where I'm going to have to break a section down? I mean, they've already been subdivided. And so belief system and common sense is thrown out the window in a lot of these surveying scenarios. I mean, what does common sense tell you? How many times does a chunk of dirt need to be subdivided on the ground? Common sense would say one time. Then why are we subdividing sections and subdivisions of sections over and over and over and over? It doesn't even pass the common sense test because it's part of a belief system. It's part of a belief system that says I must go out and break that section down or I'm not following the rules of surveying. There's only one problem with that rule. Where is it written? It's not written anywhere. 3-87 of the 1973 manual is how you're supposed to subdivide a section the very first time. Where does the manual talk about the second time? It doesn't. Well, actually, in the 1973 manual, it does, 3-95. The center of the section is a straight line between the opposing quarter section corners, unless it's already been set. They actually took that sentence out of the 2009 manual, the Bureau of Land Management. And here's another one. Okay, here's another one. Why in the world are we as a profession, and a large chunk of the profession, 30 states were carved out of the great public domain? That's a lot of surveyors. Why in the world did we as a profession take a manual from the federal government? It's not a retracement manual. It's a manual for the original surveys of the federal government's land. It's a manual for conducting original surveys of federal land. It's not a retracement manual. It only talks about retracement in one place. I can't quote 2009 manual off the top of my head, but in the 73 manual, it was 6-7, I think, chapter 6. A retracement, it tells us what a retracement survey is. And in a retracement survey, according to the manual, you can't call a corner lost. So if we're not even going by what the manual says. We're going off belief. We're going off mythology. The manual says in a retracement survey, you cannot call a corner lost, but here we are. Here we are. So it was all of that kind of stuff that prompted me to, finding multiple monuments in the ground, that prompted me to write about this issue. Another thing, any surveyor who knows anything about boundaries knows that there's two kinds of surveyors. You're either an original surveyor laying out brand new lines for the very first time for a common grantor, owns both sides of the lines that you're putting on the ground. Original surveyor creating original lines, creating new property. Or everybody knows what the or is. You're a retracement surveyor finding when the boundary lines have become established on the ground. So where does deed stakers come in there? What principle of law is deed staking following? You can't, when you're deed staking, you've got diversity of ownership on every line. So you can't be an original surveyor because you don't have a common grantor. It doesn't match the definition of original surveyor. Original surveyor is working for a common grantor who has the power to create new property lines with a subdivision. Or you're a retracing surveyor. I mean, those are it. Those are the two functions of the land surveyor, of the retracement surveyor. And that's by and large what we are today. If you're doing any boundary work, by and large, you're doing retracement work. If you're doing subdivisions, that's fine. But I would imagine 90% of the boundary surveying work being done in the United States right now is supposed to be retracement work. So where does deed staker fall into those categories? It doesn't. We made it up. It's survey mythology. It's a belief system. We even created a name for it. It's called the first surveyor concept, and you can find that directly in evidence and procedures. Walt Robillard put it in there. He created this mythology of the first surveyor concept, which doesn't follow case law. It existed in one horrible case in Florida, Rivers versus Lazia, where the judge actually said in black and white that when lines are drawn on a map, it's just as if we're talking about the subdivision lines for a section, the protracted subdivision lines for a section, the quarter section lines and the quarter section lines, the 16th lines. They were all drawn on a map. The only thing that was put on the ground in the field was the framework of the section, the 4 section corners and the 4 quarter section corners, typically speaking. That judge said, what was his name? Cowart, actually said that when the GLO surveyors drew those subdivision lines on a map, it was just as if they were running the field. Now that would be something. I would love. Who as a surveyor wouldn't love to just be able to draw a line on the map and that line has already been cut out, chopped, marked, and monumented? Done deal. Done deal. It's all over with. No, it's a 2-step process. You draw, and that's what the 2009 manual actually says. It's a 2-step process. The first step is you draw the lines on a map. That's how we how we legally contemplate these subdivision lines. But then the manual says, then you have to go to the field and run the lines. And who was supposed to do that? The GLO surveyors. It was contemplated under federal law 6-76. It was contemplated under federal law that the local 6-7, that was 6-7. It was contemplated under federal law that the local surveyor would be hired for the purpose of further subdividing the sections. That has been totally ignored by the land surveying profession. We have totally missed it. We do not recognize the authority the federal government put on the local surveyor in the role of subdividing a section. According to the manual, that surveyor is cloaked with federal intent. Therefore, the first surveyor, regardless of what you read in evidence and procedures, The first surveyor on the ground subdividing that section is nothing less than the original government surveyor. But our surveying methodology and belief system has completely thrown that out. So there we are. What about this problem here? I personally think it's kind of a big problem, because what this does is it tells the general public we don't know what we're doing. It's the physical evidence that tells the general public we don't know what we're doing. I think my definition of Pincushion Corner is it's the land surveying profession's collective confusion over our duties and responsibilities towards property boundaries. And property, just the word property, that was an anathema. You could not, when I was growing up as a surveyor, you could not use the word property. We don't survey property boundaries. It's still in Evidence and Procedures, page 2. We don't survey property boundaries. We have somewhat changed the terminology. It is our belief, and there it is, page 2, Evidence and Procedures. There it is. They're talking about a belief system on page 2. If it's the 5th edition, it's on the top of page 2, Evidence and Procedures. We have somewhat changed the terminology. It is our belief. It's a belief system. They admit it right there on page 2. It's a belief system. So why are we doing this? Well, that was a big question for me. Another thing too, at least my experience was, you don't learn, we're not teaching. I wasn't taught. I had to go find it on my own. We're not teaching surveyors, trainees, anything about the law, or very little about the law. And in this aspect of what we do, boundary surveying, in this aspect of what we do, where we're actually touching the lives of the people who live on the property. Surveying isn't an engineering project. It can't be an engineering project. For the core reason we are licensed as surveyors has nothing to do with math and measurements. It has everything to do with the citizens of the landowning citizens of the states within which we are licensed. And this is another thing I've come to realize is we surveyors ignore to a large extent the most important people in the equation. The most important people in the equation of any boundary resolution are the landowners. They're the most important people. They and sometimes are the most important evidence, and they are really actually the only evidence necessary to resolve a boundary dispute. That's how important they are. And do you think any of these 4 surveyors talked to any of the landowners before they drove those pins in the ground? Highly unlikely. Matter of fact, many of us became surveyors because we don't want to talk to people. Surveyors don't like people. We just want to be left alone. And another thing I've come to find out is if you want to be a good boundary surveyor, you've actually got to be a good people person. You've got to want to talk to people. You've got to want to hear what they have to say. A lot of times you're going to hear, stuff that is totally irrelevant, but they could be the answer to your problem if you're having a problem out there. Because the reality is, surveyors aren't needed in order to resolve boundary problems or to help resolve boundary disputes. We're deemed helpful. We're deemed helpful, but we're not necessary. The only people necessary to resolve a boundary dispute are, if it goes to court, you got to have a judge. You got to have a couple of attorneys. Generally speaking, well, first of all, you got to have a judge. Then you have to have a plaintiff and a defendant. That's all you need. That's all you need. You want to take a boundary dispute to court, All you need is 3 people. That's all you need. And but then the people generally will like to bring an attorney, so you get a couple of attorneys in there. That's it. You can resolve any boundary dispute in the United States of America with those 3 people: a judge, a landowner plaintiff, and a landowner defendant. That's all it takes, just 3 people. And the reason for that is, and this is important to know as well, I mean, has every boundary line in the United States of America been surveyed? No. Has every boundary line in the United States of America become established on the ground? Yes. And the reason we know that is because all it takes is a judge, a landowner plaintiff, and a landowner defendant, and they can resolve the boundary, because the boundaries have already, the vast majority of boundaries have already become established on the ground, which brings up another whole other issue: how do boundaries become established? And we talk about that in the book, how boundaries become established. We like to put it in terms of surveyor. Now, original surveyor went out and set those monuments, established those boundaries on the ground. Retracing surveyor finds where those boundary lines, have become established on the ground. The intent of the surveyor, proper procedure of the surveyor. Proper procedure is totally irrelevant to the establishment of boundaries. As a matter of fact, the surveyor, to a certain extent, is irrelevant relative to the issue of the establishment of boundaries. The surveyor plays a role. The original surveyor certainly plays a role, but boundaries don't become established through the activity and inactivity or the success of the original surveyor. They become established by the activities and the inactivities of the landowners. The only reason a monument has the high rank that it has relative to boundary evidence is because the people went into reliance on that monument, and that's how that monument establishes a boundary, when the people go into reliance on that monument. Even original monuments set by original surveyors, if there's no reliance ever put on those monuments that surveyor puts in the ground, it's just a piece of steel. It's just a wood stake. It's just a chunk of concrete, which begs the question: so when does an iron pipe become a monument? When does a half-inch rebar become a monument? When does a chunk of concrete become a monument? And they become a monument when the people go into reliance on them. And then of all things, guess what happens? Their property rights attached to those monuments and the lines between those monuments. It's all about property rights. And of course, like I was saying earlier, that was one of the things you couldn't say. You couldn't, back in the late 1970s and the 80s, and I don't know, maybe it continues to this day. Fortunately, I'm not having to work with a bunch of idiot surveyors, but I still see it. I still see it. About something about surveyors. In fact, I had a little article just as recently, like three months ago. That's the peanut gallery over here. Stop it. Just as recently, about 3 months ago, somebody wrote an article about how surveyors, can't do this, can't do that. Surveyors, I was in a deposition about 3 months ago, and it was on a riparian boundary issue. Okay, a riparian boundary issue. If some of you don't really know what that is, generally speaking, it is a projection of the upland boundaries in some direction representing the riparian rights of the upland landowners, or the location of the riparian rights of the upland landowners. Now, this has been kind of fascinating for me. Over the last 10, 15 years, I've gotten involved in riparian boundary issues. Whereas land surveyors, when you talk about the terrestrial boundaries, and we even have articles written by well-recognized our experts talking about how land surveyors cannot determine where property rights are, cannot determine ownership of property, cannot determine this, basically can't know the law. That's what I was told too. You don't know the law, Jeff. You don't know the law. As a land surveyor, you don't know the law. You can't know the law. You can't opine on the law. You can't do anything about the law. Nothing relative to legal issues. You can't. You're just Sergeant Friday. Just the facts, ma'am. Just the facts. But it's kind of amazing. We're the same surveyor who maybe does a terrestrial boundary won't call that a property line. Can't do that. Can't be dealing with property issues. Yet, when there's a projection made of a riparian boundary rights line, that's what they're called. At least down here, that's what they're called. Riparian rights line. They have no qualm over calling it a riparian boundary, riparian rights boundary. No qualm whatsoever. But you get up on the terra firma, can't call, no. That's just a boundary line. I don't know where the property rights are. I'm not claiming that's where the property rights are. I'm not claiming that it is or it isn't. It's kind of fascinating, really. But anyway, I digress. So I was in a deposition over on a riparian boundary issue, and got into that same discussion with the attorney. He's starting to ask me about my opinion on the location of the riparian boundary lines and the riparian rights, and how, as me as a surveyor, he really was digging in. And me as a surveyor, how can I give an opinion? These are equitable decisions, and you're not an equity judge, are you? You're not a law judge, are you? No, I'm not a law judge. And he says, well, how is it that you then can give an opinion on where riparian rights are, or riparian boundaries are? I said, because that's what I do every day. Every day I go out and do surveying, I'm giving an opinion on where I think the property rights are located. Well, you can't do that. Only a judge can do that. This is the same stupid line that the surveyors have been chanting in my entire career, over 40 years now in the land surveying profession. You can't determine where the property rights are. You can't determine where the boundary lines are. Those are legal questions. You can't make that determination. It's, of course, more survey mythology, belief system. You see, I've got a really simple analogy. Well, first of all, this idea surveyors can't know the law. Ignorante juris non excusat. Ignorance of the law is an excuse for no person above the age of majority in the United States of America. We all are charged with knowing the law. Can anybody know all the law? Nobody can know all the law. Then how can you be responsible for knowing the law? Because that's how our system's set up. You're responsible for knowing the law and applying the law in everyday walk of life. Walking down the sidewalk, you as an American citizen or even a visitor you're supposed to know and apply the law. So here's my analogy. It's the stop sign analogy. You're a licensed driver. As a licensed driver, you are supposed to know the rules of the road. In other words, you're supposed to study and know what the law of the road is. That's the law. You're supposed to know it. And when you come to a stop sign, you are supposed to not only know what the law is, you're supposed to apply the law to the situation at hand. In other words, you come to a stop sign and you have to make a decision. What is that thing? And this is the perfect boundary analogy. What is that stop sign? That what it is a legal question. It is a stop sign. You are supposed to know that. You are supposed to recognize that. You're a licensed land surveyor going down the boundary lines. What the boundary is the legal question. It is the southwest quarter of the northeast quarter. That's what it is. That is a legal question. That's not your question to argue. It's your question to recognize and then apply the law to. So you come to a stop sign. The legal question is, what is it? It's a stop sign. I'm not arguing that it is. It's a legal question. In a boundary scenario, what is the property? It's the southwest quarter to the northeast quarter. It's lot 9 of Garfunkel subdivision. It's that certain tract of land described in that meets and bounds description and that certain deed booking page. That's what it is. I've got to know that. And then I have to apply the factual situation at hand. As a driver, I come to the stop sign. I'm supposed to stop. I'm supposed to apply the law. Now, in the boundary scenario, the question might be, where did you stop? Where did you stop? That would be more in tune with the question we're talking about here. So you go out to the field, you're trying to find the southwest quarter of the northeast quarter. It's the same question. That's what it is. Now, where is it? Where do you stop? So even as a citizen driving down the road, you're supposed to, number one, know the law, the rules of the road, and number two, apply the law to the factual situation at hand. Why is it in the United States of America that only the surveyor is exempt from knowing the law and applying it? So that's just another bit of the belief system, mythology surrounding surveying. We're not supposed to even know what the law is. We can't apply the law. That's practicing the law. Evidence and procedures, page 2, top of the page. We're the only people in the world who, in the United States of America, who aren't supposed to know and apply the law. It's absolutely amazing to me. It's absolutely amazing. But anyway, surveying mythology, that was the main reason for writing this book, because I had to wrap my brain around it. That's one of the reasons I went to law school. I had to wrap my brain around it. And so the way I describe this book, it is the minimum mandatory property law to understand what the problem is. And then I have some solutions in the back of the book on what we can do. Now, a lot of people, the solution is, well, we just pull them up, right? Well, I'm not gonna say that. And then the question becomes, well, which ones do you pull up? Of course, you're out there in the field, you're wanting to drive a new iron in the ground, and so you think that yours is the correct one. So you're going to pull all the other ones up, right? Not so fast. Matter of fact, in a perfect world, we wouldn't even, in my opinion, when you come to the vicinity of a corn and you find a monument there, you as a surveyor have to make a decision. It is either representative of the corner or it is not. And if it's representative of the corner, now how do you know if it's representative of the corner? Your measurements? Well, that's part of the problem here. The measurements aren't working. And then, of course, what do the surveyors ask? What's the question they ask? How close, Jeff? How close? How close is close enough? I'll give you a little hint. The only people who ask that question are the surveyors. Nobody else asks that question. It's kind of irrelevant. They also have another Latin phrase, de minimis the courts, de minimis non curat lex. The law does not concern itself with trivialities, but here's the problem. Surveyors are ate up with triviality. They are ate up with triviality. This is triviality, my friends. This is triviality. So how close is close enough? Is a couple of 3/10? Is that close enough? How about a couple of feet? How about 10 feet? What about 70 feet? Dykes versus Arnold, Oregon, 2006. How about 70 feet? The courts never asked that question. The only people asking that question are surveyors. It's irrelevant. How do you know that the pin you're looking at the corner you're considering is 10 feet off of what? The crap you started from? Back a quarter of a mile down the line? Now that's been the thing that just blows my mind about what surveyors do, especially in the sectionalized lands, in the public land survey system. I mean, they're willing to throw out that quarter corner because it's not on a straight line between the opposing section corners. What makes the opposing section corners so great? Did you find the original GLO corner there? If you're not finding original GLO corners at the section corners, original accessories, original corner positions, the monument might not be there, but through the accessories and whatever, you found the original GLO position. Now talk to me about how that quarter section corners is offline or not at the midpoint between the opposing quarter section corners. And on all these court cases that you see on this issue, they never they don't dig down into that far into the weeds when they write their opinions. So unless you were there, unless you were at the trial, unless you have the trial evidence in front of you, you really don't know what they were dealing with. Dykes versus Arnold, we don't know what I forgot the surveyor's name. We don't know what the surveyor came along in early 2000, found at the quarter section corners. All we know is that he found quarter section corners, did the sign of the cross, and Derek's 1899 redwood post was 70 feet off. So of course, Derek, the 1899 county surveyor, is a bum. We gotta kick him out, which ignores the most important people in the whole scenario, and that's the landowners on the ground. The landowners on the ground. So, those cases, because the judges who write those opinions aren't really interested in that esoteric surveying stuff. I mean, and it rarely comes up. Matter of fact, I don't think I've ever read a boundary dispute case involving sectionalized lands, breaking the section down and all that good stuff, where anybody proved anything relative to the original section corners or quarter section corners. Doesn't mean that it didn't happen, but they don't talk about it. And I have never read a discussion about what they're using to break the section down with. Never. Maybe one or two times in one of those cases. So my question is always, okay, so that corner 70 feet off, well, what about the ones you came from to get this one 70 feet off? What about those? And what makes them so good and this one so bad? Maybe all of them are bad and this is the only good one. So, those are the kinds of things. So you come to a corner position, either that monument that's there or multiple monuments that are there one of them's representing the true corner location, or it's not. Now, I'm going to sit here and say that there isn't a good reason to set another pin when there are already pins in place. Matter of fact, I can give you a good case, Weber versus Kroger out of Tennessee, like 2019, where a surveyor came along in 2016, 1913 subdivision. And in this neck of the woods, those subdivisions back in the late 1800s, early 1900s, they set wood stakes out there for the property corners, kind of similar to what the GLO surveyors did down in this neck of the woods. They set wood stakes at the section corners. And Gideon Fitz, the Surveyor General for the Mississippi Territory, writing to the Secretary of the Secretary of State of the United States, I think that's who was in charge of the system. There wasn't an interior department back then. Said that these green stakes we're putting in the ground won't last more than 2 years. So what were they expecting to happen? What were they expecting to happen? They were expecting people to buy the land and go in and occupy the land, build their improvements, and then those green sticks wouldn't be necessary anymore because people would be on their land and everybody would be happy. Everybody would be happy except the surveyors who come along later, and none of this stuff works. You know, it doesn't match our math, so we got to move things. And you know, section corners are supposed to be immovable, forever placed in position by federal law. But people are out there moving, and in most cases, the people moving them are land surveyors, which is a crying shame. That's another why. It's a belief system. Why? If you're doing retracement surveying, even the manual says you can't call a corner lost during a retracement. So why are we doing it? Mythology, survey mythology. One of the problems, the biggest problem, I think, with this aberrant retracement practice that we have on our hands, if you got people staking out the deed, that's aberrant behavior. That is not correct retracement theory. One of the problems, another problem, is that the definition of surveying provides cover for aberrant survey practice. The definition of surveying that comes from the NCEE, National Council of Engineering, Examiners for Engineers and Surveyors, NCEES. That definition of surveying has been around way too long. It was probably formulated in the late 1950s, maybe early 60s, somewhere in there, by surveyors and engineers who didn't know any better. But here it is, still to this day. It's in most, it's in the definition of the surveying is in the vast majority of state statutes across the country, because it's in the NCEE model law and model regulations. It basically boils down to the one sentence, I think it's subparagraph C, when describing the practice of surveying. And one of those subdivisions of that definition says the practice of surveying is locating, relocating, establishing, reestablishing, and retracing boundaries. Now, just think about that a second. The definition of the core definition, it's got all other kinds of things that surveyors do, none of which we do by ourselves. Who's not measuring the earth these days? I mean, Google Earth has measured the earth 3 times since I've been talking. who can't use the tools. The the one part of that definition that touches on the core issue of why we're licensed and regulated for the protection of the property of the people of the state of whatever state you're licensed in, Alabama, Florida, Tennessee, Mississippi, Georgia, Arizona, Utah, Colorado, California. The only reason you're licensed is for the protection of the people of the state. And what is it that we protect about them? We protect their property interests. That's what we protect. And so the definition, the core definition that touches on that issue is the one I just paraphrased. Surveying is locating, relocating, establishing, reestablishing, and retracing boundaries. What is locating mean? Well, I could see locating being kind of a description of retracement surveying. Okay, the boundaries are already established on the ground, and my job is to go out there and locate those boundaries. Now, what does relocate mean? It means just what you think it means. It means move to a new position. So I don't want to do all that retracement work. I know that's what I'm supposed to do, but I don't give a crap. I don't want to do that retracement work. It's too hard. I'm just going to relocate the boundaries to where they should have been. So I do. This is what I call the deed staker. I go out and I stake that deed, and now I'm relocating the boundary lines to where the deed says they ought to be, assuming I have the correct starting point. If I have the incorrect starting point, then I'm not even close. I could be a block away, but be that as it may. So when I get called in front of the board, so I'm not going to do a retracement survey, and I know I'm not an original surveyor. I'm just going to go stake the deed out and let the chips fall where they may. And I start a lawsuit. And like, for instance, Kroger, Weber versus Kroger, and they go to court and it goes up on appeal, and everybody spends about $50,000 each. That's my equivalent of amputating the wrong leg. We amputated, the surveyor amputated the wrong leg. I mean, it got it completely wrong. Sent everybody to court. Everybody spent $50,000 each at minimum over a nothing burger. And then let's just say that Weber decides, because he hired the surveyor in 2016, decides to sue the surveyor, and it goes to the board. But this surveyor surveyed the wrong boundary line. He didn't survey our property line. He just put some crap out there on the ground. It doesn't match anything. It came off some sticks and stuff, and he couldn't even explain what he did. I want his license. He caused us we lost $50,000 because of this guy. And then that guy gets up in his defense, and they're going to say, well, can you explain yourself? The board's going to say, can you explain yourself? He said, I just did a survey just like the statute says. I relocated the boundaries. Oh, okay. Well, you're good to go. Relocate provides cover for aberrant, negligent, unconscionable, stupid practice. What about established? Survey, see here, just a basic misunderstanding. Surveyors establish nothing. Now, I will go ahead and admit I have used the word establishment with, and surveyors in the same proximity, because you see it in some of the court cases. Well, the surveyors came out and established about. No, the surveyors came out and put pins in the ground in the final analysis. The surveyors came out and put pins in the ground. Boundaries become established through the activity and inactivity of the landowners. So the basic definition of surveying has a basic misunderstanding about basic property law. How do boundaries become established? The definition seems to think surveyors do that. Locate, relocate, establish, reestablish, and retrace. Of those 5 elements, 2 are completely illegitimate. 1 has cover for aberrant behavior, and only 2 of them come even close to identifying what we're actually supposed to be doing. There's this company called Visalign. I wrote about them a couple of years ago in POB magazine. It's a banker, retired banker, and a guy who knows enough. It didn't even have a CAD program. It had some kind of program where he could plot out some deeds. And they started plotting out deeds, and then they would take a Google Earth map, and they would lay it over the deed, and set the map, the aerial photography over those deed lines, and they would create this document plat. I don't think they call it a plat, but they would create this document. Looks a lot like a survey. Create the document on like 8.5 by 14 legal size paper, and then they take them to the bank. The bank orders them, and they give it to the bank for a fee, and the bank then takes a look and decides whether they're going to lend money on that property or not. But if looks like there's problems or something, maybe they stop, take a time out. Well, let's call a real surveyor and let's find out what's happening. So they were operating in Mississippi and some other southeastern states, and Mississippi board went after them for practicing surveying without a license. And you would think this is a no-brainer, right? No, it wasn't a no-brainer because of just what I talked about. Visalign, even though Visalign was drawing up a deed and then consciously making a decision of where that deed sits on the face of the earth based on a Google Earth map, which is really what surveying is supposed to be doing, because they weren't locating, relocating, establishing, reestablishing, or retracing boundaries, they weren't practicing surveying. The definition of surveying doesn't even describe what we do. And in my opinion, Visalign was practicing surveying, because that is exactly what surveyors are supposed to be doing. You take a deed, and then you go out into the field and you do your surveying work, you do your retracement work, and then you make a conscious decision as to where you think, in your well-reasoned opinion, the property lines are located on planet Earth. That's what Visalign's doing. And now that they've passed muster with the Mississippi board, they're going all over the Southeast, and we're heading up to Ohio next. They're in now. I can't quote exactly where they are, but they're in Mississippi. They're coming over to Alabama. They're in Tennessee. I think they're going down into Florida. They're in Arkansas. They're heading up to Ohio. Taking their wares with them and selling services that they're actually doing what surveyors are supposed to be doing. I mean, without going to the field, they are taking the property description and they're making a conscious decision by placing that Google Earth map over it as to where that property exists on the ground. That's our job. But you can't prove it by our statutes or our definitions of surveying, because you see, the people who wrote that definition, I know who they are. They're the same people who told me I can't know anything about property law. I'm just a surveyor. They know nothing. They knew nothing about property law. They're just surveyors and or engineers. Therefore, they did everything in their power that they could to not mention the word property in that definition. Here's the reality. Here's the truth. When you have done your job as a retracement surveyor, every boundary line in the United States of America, with very, very few exceptions, has already become established on the ground. Your job as a retracement survey is very easy. There's only one question. A boundary determination is a two-part question. What is the boundary? What is the property? And then where is it located? The what is the property isn't our question. It's a stop sign. We accept that. It's the southwest quarter, the northeast quarter. We accept that. That's what it is. I don't have any argument with that one bit. The only question I have, we only have one question. Where? Where is it? That's our only question. We only have one question, for crying out loud. Only one question. And then there's only two principles of land surveying. You're either an original surveyor laying out brand new lines for the very first time for a common grantor, or you're a retracing surveyor, finding where the lines have already become established on the ground. Brown was right. Surveying is easy. There's only one question, and there's only two fundamental principles. Of course, we've mucked that up. Well, I've talked about that. We've mucked that way up. We've mucked it up. We've screwed up the definition of surveying. It doesn't make any sense to anybody, and it allows for aberrant behavior. But when you get down to the common law, what it says is we have only two fundamental principles. And then, well, I'm getting into the litmus test. Let me back up. Why don't we go down this road? Because it's just a lot easier and a lot less complicated to just go out and stake out deep, okay? And then just let the chips fall where they may. And the other good thing about that advice was I can check my math. I can check my closures. That's the reason we love it so much. We don't have to do any of the judgment stuff. We don't have to weigh any evidence. All got to do is find the starting. What do you need to be an expert measurer? What do you need to be a deed staker? You need a starting point and an azimuth. That's all you need. Then you can go stake out any boundary in the entire country. And that's when you say you're staking out the boundary, you're admitting that you are that you don't know what you're doing. Because when you find yourself saying, let's go stake out the boundary, you're not doing surveying. You're not doing retracement survey. You're doing something else. You're doing a stakeout. And this is the end result of the stakeout right here. If every boundary in the United States of America depended on the next measurement to come along, then no boundary would ever be settled, because all it takes is another measurement, and now we're in a new position. We relocated it again. You can't check your math. You can't check a closure to see if you got it right, but there is a litmus test. And we'll kind of wrap up with this. There's a litmus test to figure out if you got it right or not. First thing is, you got to know that there's only one question. Where? There's only two principles of surveying. You're an original surveyor or you're a retracement surveyor. So you're a retracement surveyor. If you're original surveyor, it's much about precise measurements and doing it as accurately as possible, as precisely as possible. It's about math and measurements. Once you get within the perimeter boundaries, a perimeter boundary is going to be a retracement survey. Those subdivision lines you're putting on the ground, that's the original survey. That's all about math and measurement. But in retracement surveying, there's no closure that you can do to figure out if you got it right. There's no mathematical formula, but there is a litmus test. And here it is. First is we recognize that we only have one question and that we're in retracement mode. Then the next thing is we've got to know what our standard of care is. The standard of care is what all other reasonably prudent practitioners would do in like or similar circumstances. That's a national standard of care. A national standard of care. It applies to all professions. That is the common law standard of care for professions, what other reasonably prudent practitioners would do in their like or similar circumstances. So that's your bar. As long as I'm operating up here, here's what all reasonably prudent surveyors would do. And I'm operating up here. I'm a reasonably prudent surveyor. By definition, I can never be negligent. I can never be negligent because negligence requires 4 elements. A duty owed, failure in that duty, that's the standard of care, failure, falling below the standard of care, causation, you owed a duty, you failed in the duty, and because you failed, causation, there were damages. 4 elements. They got to prove all 4 of them, not 1, not 2, not 3, all 4. So if they can't prove you fell below the standard of care, you can never, ever, you might make a mistake, but you're not negligent. You won't be negligent. And we can get into the difference in a minute, but they won't get the damages for negligence, okay? It's about the damage. So you got to know what the standard of care is, and then you need to know what your evidence criterion is. Your evidence criterion is best available evidence. The best available evidence that the reasonably prudent practitioner would gather and evaluate in like or similar circumstances. You do that, gather and evaluate the best available evidence that other reasonably prudent surveyors would gather and evaluate in like or similar circumstances. You weigh that evidence, and then you render a well-reasoned opinion on where you believe the property lines are located on the ground. And then one other step, if you can explain the boundary location doctrine that supports your results, then you've done it. And you will have done 10 times more than anybody else who shows up in court. Because most surveyors in the United States of America don't even understand what I said in that last part, the boundary location doctrines. Maybe some of you are out there shaking your head, but what is he talking about? Don't go survey property boundaries if you don't know what I just said. So if you can do those things, you've passed the litmus test. And there's a 99% chance the surveyor on the other side wouldn't even understand what you said if you just said that. Wouldn't even have a clue what you're talking about. And that's when you know that you're going to win the case. Another thing real quick on winning the case is you've got to know as a practicing professional, you may end up in court. And if you end up in court over a boundary dispute case, let me just give you one little hint. I'm going to tell you what the judge wants. All the judges, they all want the same thing. First of all, they do not want boundary dispute cases. They hate them. They hate them with a passion. Why do they hate them with a passion? Because nobody can come into court and explain what the hell is going on. And therein lies the key. If you can come in and lead that judge out of that case, that's what he's looking for. She's looking for. Lead the judge out of that case. Show the judge the way out. You're going to win. Because that's what the judge is looking for. Somebody to come in and explain all this crap. Surveying is so esoteric, even surveyors don't understand it. And that's what the judge is looking for. Somebody to come in and bring order to the chaos. Because all you got to do is read just a few court cases where they give you some of the testimony of surveyors and trial. It's just it's unbelievable. Tillman versus Bennett, Florida. The entire case that was decided on the depositions of the surveyors. It's a great case. It doesn't include the depositions. I had to buy the depositions separately, but the depositions of the surveyors just absolutely fascinating. What surveyors will get up on the stand and say with a straight face. But anyway, Trent, I don't know, it's about 17 minutes after. I don't know if you want me to take some questions or what do you want to do?
Yeah, no, it was one, I love your passion, obviously, and I think everybody on here loves your passion. There was just a couple of quick comments, and then I'll open it up after that. George, just kind of going back early on in your conversation, if you're doing subdivision work, you're doing both retracement and original surveying work. And then the second comment to that was we have the same obligation to adjoiners as we do to our client, which most of us as surveyors definitely know that, but some of the younger ones on here, which is, the whole thing behind mentoring. And then on the question side, Pat said, if your section was subdivided using the procedure under 1973 manual prior to the 2009 publication, you would need to work within the interior now. Would you use the 73 or 2009 manual? And Mr. Parrish jumped off, but I was going to have Steve jump on that. But I would say in my own mind, it would be obviously it's based on the manual in effect at the time of the survey. So in my mind, that's the 73 manual, unless somebody corrects me otherwise. But
well, so you're talking about stuff that I don't encounter. I have yet to meet a quote unquote virgin section.
Right.
Every section I go into has already been subdivided more than once. And again, I'll stand on the comment that I made that as contemplated under federal law, the first surveyor on the ground in an attempt to subdivide the section is fulfilling the role of the original GLO surveyors. So I would say if you were going, I'm coming upon a virgin section that no one's ever touched before, okay? And it's 2021. I am, according to the manual, I am the original surveyor. So I guess I'm going to break out the 2009 manual and see what it says about breaking that certain section down. That's my answer.
Yeah, no, that's great. I love it. Danny had another good one, reestablishment versus retracement. What are your thoughts on that one?
Well, first of all, I think establishment is not the right term.
Okay.
That's not what we do. Surveyors don't establish and then reestablish. Those terms are so ambiguous, you can make them mean whatever you want them to mean. Okay. I could actually see relocate being used in the context of, well, I'm I'm going to go out there again. I retraced and located these boundaries. Now I'm going to go out there again and I'm just going to relocate. But the problem is for the uninitiated is I just take that word right out of the definition. It says relocate. If you go to Webster's, relocate means move to a new position, which is basically cover for deed staking.
I love it. I love it. Kent had his hand raised up there. Go for it. Maybe.
So wait, can I ask a question?
Oh yeah,
you're up.
Okay, you got me. Good. All right. So Jeff, I don't know if you remember me, but I was president of the Little Egyptian chapter in Southern Illinois back in the mid '90s. We had you come and talk. We stayed at the Metropolis Casino and all that stuff. Does that ring a bell to you?
Yeah. Your name rings a bell for sure.
Yeah, for sure. So I heard you for the first time in like 1991-ish. And I can remember you doing a presentation at one of the Illinois Professional Land Surveyors conferences. And you left the room and the entire room was freaking dumbfounded because everything you said made so much sense, but not to the majority of the group of this room. Because they were like, they're like expert measurers and I can measure better than the other surveyor and this and that, and even at that time, early in my survey career, I'm like, first of all, I'm like, what the hell am I getting myself into? That was my first response. But now I've been doing it for 30 years and I've still followed you, the whole Pincushion thing, huge fan of that. Now that I've been doing this for 30 years, the one thing that jumps out to me, the biggest problem that we have is lack of good mentoring. And what happens, I tell this story all the time. I know of a surveyor he's a great surveyor, very well respected here in Arizona. He did a survey, and part of the survey was resetting a aliquot corner, which was a 16th corner, okay? Sent his guys out there to, set this corner, blah, blah, blah. Well, the guys in the field, they don't know what they don't know. They're being sent out there to set a corner. That's their instruction. Go out, set this corner. Boom. All right. In this case, his crew went out there and set a corner. The thing is, they set a nail on top of a transformer box. That's where they set the corner, on top of a transformer box. Because honest to God, they don't know what they don't know, right?
Right.
What needs to be told, what needs to be driven into the heads of these field surveyors who aren't getting enough mentoring as it is. Listen, first of all, if we're doing our due diligence properly, we're doing the preliminary survey, we've done the research, we're doing the preliminary field survey, we're visiting initially all the corners that we're going to set, right? That would be the proper due diligence. That doesn't happen hardly ever anymore. So now the guys go out, they go to set corners, and they're just instructed, go set this corner, go set this corner. They don't know that if it's 2 tenths away from another corner, they don't know what they don't know. They have been instructed to set a corner. That's what they do.
Stake out the boundary.
Stake out the boundary.
Exactly.
And it's like, you know what? It's like my guys, I tell them all the time, if you go to set a corner and you find a corner within 5 tenths a foot of that corner, call the office. Don't set the corner. Let's reevaluate the situation. And I just don't think that's being said enough.
No, you're right. And part of that is, just the way we operate these days. When I first started out, there were 4-man crews. I started out as a butt chainman. So the head chainman was teaching me how to become a head chainman. And the instrument man was teaching the head chainman how to become an instrument man. And the party chief was teaching the instrument man how to become a party chief.
Yeah.
And it took years to get through that cycle, right? It wasn't something that you weren't moved up in 3 months.
Oh yeah.
you did your war battles for a long time. Yeah.
And I knew some professional chainmen.
Sure.
Charlie Dunn was a professional chainman. Yeah. They tried to work him up to get on the instrument, but it never stuck.
Yeah.
It never stuck.
Yeah.
Yep. That's good stuff.
Yeah. So what can I ask one more question?
Go for it.
So these surveyors that think they're better measurers than the previous surveyor, What is your response to that?
Well, that's part of the pincushion corner.
Yes.
And that's what that's what I was told growing up. You don't need to know anything about property law. You don't know all we are expert measurers. But the problem with that is if that's all we've got in today's society, we've got nothing. Because who cannot go out and get the expert measuring tools and then go measure expertly? You can't regulate the tools. We can't determine who can go get a drone and who can't go get a drone. We can't determine who can get GPS equipment. We can't. Those things are beyond our control. And anybody with the wherewithal can go out and start and get expert measuring tools and go out and start gathering data and then selling that data to a willing, a willing buyer. It's called the free market system.
Well, on that note, let me ask you this. I was recently contacted by a surveyor in Canada, for example, okay? And there is a black market, let's say, for previous surveys in Canada, where people are selling previous surveys. I don't even know how to explain it. I mean, it's almost like the way he explained it to me was almost like a iTunes for previous surveys, where people are like selling their records and their previous surveys to folks that are acquiring property.
Mm.
Oh Lordy.
Yeah, and we have the owner's affidavit here.
Yeah.
No changes. Well, what about this house that wasn't on the property before? Oh, okay.
I love it.
So crazy.
Andrew, go for it. Speaking of Canada.
Speaking of Canada, yeah, just on that last point about selling previous data, there was a movement here in Alberta by the banking industry of all people that, hey, previous real property reports are fine. Absolutely. Doesn't matter how old they are. Doesn't matter when they were done. Previous RPRs is okay. When we had the boom, like when we had the last oil boom, it was insane. Yeah, and you could go onto any property, you could see a garage that had been built, a separate garage, and it's not on the original RPR, but that's acceptable. It was really bizarre.
Crazy.
Now, about the mentoring, wow, here in Alberta, once again, anybody can pick up a GPS and work for a land surveyor. We have caveats in the Land Surveyors Act, I can't remember which one, that says you must be under the direction and supervision of a land surveyor. Well, all well and good. When I was a tech in the field all over this beautiful, huge province, I saw my land surveyor exactly 3 times in the field. Once he just happened to be driving past us to go fishing. He had no idea what I was doing. No idea. I could be tilting the prism to make closure. I could be doing all sorts of weird things, and he would never know. And once again, back in the boom, especially in northern Alberta in the oil patch, holy mackerel, the stuff that I see, the pincushion effects, we have marker posts up here to delineate where the boundary monuments are, and you'll see 3 marker posts beside each other. One from way back in the 1900s, like the original survey, and one from 2010 and one from 2014. Marker posts sticking 4 feet out of the ground. Come on, guys. Like, accept the tolerance, accept the close enough. When is close enough? And if you're not sure, call the office. Once again, direct supervision of the land surveyor. I don't want to say it was too busy. It was too busy for people to care. It was too busy for the oil companies. It was too people for the landowners, too busy for the banks, for any of these people to care. And it's now a shambles. In 2021, trying to do a retracement survey, you got to get down on the ground and sort out which is the original monument. And it's horrible. I tell my students that if I ever catch them doing a double monumentation, I will there will be consequences. I've got a long memory, so there will be consequences.
Trent, can I say one more thing?
Yeah, go for
it. So Andrew, first of all, you nailed it, man. No doubt about it. I've got a guy that works for me currently who has worked in the public sector for 20 plus years. And when you work in the public sector, budgets don't matter, of course. And you are allowed to do research to the nth degree, back to the GLO notes, BLM plats, all this stuff. But at the same time, that can be a detriment, because when you go back that far, I mean, measurements were done to a certain, let's say, tolerance or error ellipse, and you get hung up on that. And it takes you to a place. Sorry, hold on. It takes you to a place that is not friendly to surveyors, and it ends up costing a shit ton of money, and then it ends up putting people in court. It ends up in a really bad place from a survey perspective. A lot of surveying is common sense, and Jeff talked about it earlier. Common sense. We're not there to rock the apple cart and end up in court. That's not why we're there. That's not why we exist. We're there to make everybody happy, right? Does anybody disagree with that?
Yeah, both sides, your client and the adjoining property, absolutely. Be it Walmart on one side and Joe Blow on the other side. Both parties to that boundary have to be happy. Absolutely.
Exactly. George had your hand. Go for it, George.
Okay, I'm one of those guys that didn't want to go in the office and get licensed, and so I stayed in the field for about 15 years before I even sat the exams. And I was lucky enough along the way to have some very good mentors. I had some that weren't so good, but luckily the majority of mine were very good, took an interest in me and had an interest in the profession. They took the time to explain what they needed me to do. They took the time to explain to me how I needed to do it. And because of that, when I took the exam, I was able to pass the exam fairly easily both days. I hated it. I mean, I felt like I'd been put under a shop vac for 8 hours, but my head sucked on. But hopefully I've been able to, in my career, give back some of that mentoring to some of the people that I've worked with and have worked with me. And I say with because I don't like the word for. It's a team effort. And if you don't support your staff, they're not going to support you, and you need to give them the information and the tools to do the job.
And I will attest that you have done that, George.
Well, thank you, Dave.
Hey, George, you mentioned something that I am incredibly passionate about. I'm 30 years into the profession, let's say, and I honestly thank God every day that I had the most amazing mentor from day one in the surveying industry. And a lot of people in today's world don't have that. And as a result, poor practices are being passed along to these young surveyors. And it's adding to the problem. And I don't mean to be like a Debbie Downer type thing, but mentoring is so freaking huge. And as we lose these mentors, we're losing pieces of the profession, and it's crazy. I'm not sure what the solution is moving forward, but if there's anything I can do to be a part of it, I want to be a part of it.
Trent, I would say that probably technology is one of the biggest problems that we have today, because it is so easy to send one guy out with a GPS receiver to go tie stuff or go find stuff. And who's supervising him? Even when we had 2-man crews, you still had 2 guys looking at each other. And if they were doing their jobs, they were talking to each other and helping each other out. When you were doing calcs to do stakeout, I always had my chainmen check my work. They liked checking my work because they were learning from it. I liked them checking my work because I had a chance to avoid screwing up, which usually costs money. I mean, it's a no-brainer, and we don't take the time anymore, it seems like, because it's too expensive for me to go out in the field for 4 hours a day rather than be in the office answering phone calls and putting together proposals for new work. I mean, it's ridiculous. We need to take care of educating our staff, and that means going out there and walking around with them to find corners. We don't run lines anymore. We just go to positions on a piece of paper with a picture and look for stuff maybe with a shovel. I don't know. It's sad. We need to do a better job.
I will say, just to be respectful of Jeff's time. And so coming up at the Western Conference, we have like 6 or 8 different roundtables. And a lot of the topics are a lot of what we're talking about right now. So I've talked with Chrissy about making sure we have a recorder in the room so that we actually record a lot of this and all of these roundtable stuff so that we can kind of create minutes and, formulas and that kind of stuff moving forward. So, but we'll go back to anybody have more specific questions on Jeff's topic itself? I mean, we can sit here and we can definitely beat the mentoring horse forever, but go for it, Peter.
Yeah, I just have a quick question about we see this over and over and over again with these terrible definitions of land surveying. I live in Alaska. My definition is way worse than the NC's definition. It is so all-encompassing that it's not going to be surprising when we get sued and lose whatever lawsuit is in the future, because it's going to happen and it's already happening. How do we change that? How do we move forward from that? Is there a path forward?
Yeah, good question.
Well, I'll just throw my 2 cents worth in. In most cases, it's up to our boards to correct these definitions or to further define them. I know the NCEE model law definition, which is the one I was talking about, that's meant to be a statute, and it is statutorily enacted in just about every state that I'm licensed in. That same terrible description of what property surveying is all about, or boundary surveying is all about. But the fix, which I've talked about on many occasions, is then at the board level, the board could go into the administrative code and further define what those terms are. They could define what does locate mean? Well, locate means a retracement survey. Retracement means retracement. Reestablishment means, or establishment means original survey, and so on and so forth. They could further define those terrible terms without having to get the NCEES involved to do it, because I've already been there and they don't even know what I'm talking about. But then you're looking at a board in many cases that has, more engineers and surveyors. I've also gone to boards to talk about this, and they don't know what I'm talking about either. So it really is going to have to start at the society level, where the society gets involved in trying to fix this problem. There's only two policing mechanisms for the primary 2 policing mechanisms for any profession are board action, and I'm talking about any profession, legal profession, medical profession, engineering profession, land surveying profession, board action, and litigation. And neither one of those work very well for the land surveying profession. That could be a whole other discussion, but the surveyor who starts the problem, amputates the wrong leg, puts the spike on the rail and derails the train, rarely gets sued because they only have so much money. So neighbor sues neighbor. You got the neighbors warring with each other now, and the surveyor just skates. The surveyor just walks on, what's the problem here? I'm just telling you what your problems are. Of course, I can't solve any of your problems. So it could easily happen at the board level, but the boards have, in my experience, have deaf ears. They don't know what you're talking about. The NCEES, I've been in touch with Mr. Cox, the executive director there. He hasn't got a clue, doesn't even know what I'm talking about. And so it's going to take the surveying societies to actually, go enforce and enforce some of these changes to happen.
Yeah, and I'll say kind of something along those same lines, Peter. It's like I've been trying to find a way and like Jeff says, finding one voice, right? We got to keep talking about the same voice. Everything in the survey profession is 50 different ways and 50 different laws and 50 different, licensing boards and everything else. There's not one voice to describe anything. You can look up engineering and it's the same definition damn near across all 50 states, right? And so we don't have that on the survey side, and that's something that needs to be changed and it needs to be looked at. And, like Jeff says, he's been preaching it for a while, but it's just going to take a lot bigger voices to kind of get things to go. And then you got to look at all 50 state, legislative sessions, right? It's going to take every legislative session to get through and get that name changed and verbiage changed. So it's an uphill battle. Go for it, Jeff.
Trent, I just want to say, I'm going to have to beg out of here.
No, you're good.
I just want to say thank you so much for having me on your program.
Thank you for coming.
I think that what you're doing here is fantastic.
Thank you, sir.
I'd like to come on again some other time. And
I love it.
Yeah, we could talk.
I'll get you back.
I didn't even get off slide one.
I know. I love it. No, I definitely, everybody would appreciate definitely your time. And then, of course, so I'm part of the conference committee for the Western Regional Conference. Mr. Lucas is joining us for the conference as well for a few days. We're looking at doing a mock trial as well. Those are always fun. So if you want to see more of Jeff, come out west.
Thank you, gentlemen. Thank you so
Jeff.
much.
Thank you.
All right.
Thank you, Jeff.
We can still stay on if you guys want, but yeah, I know Jeff's a busy man, so we want to definitely be respectful of his time. But if anybody had anything else they want to chat about,
hey TK,
go for it.
And this is the funniest thing ever, because I saw Jeff Lucas literally do a presentation in front of the Illinois Professional Land Surveyors back in like 1991-ish, I would say, and he was like, it was amazing to me. And I was new in the profession. He made such an impact on me because he stirred the pot with all these other guys who've been doing it for like 20, 30 years at that point. And I'm just like, I am going to listen to this guy because he's got something going. And here we are like 20, 30 years later, and he's still talking about the exact same thing.
And he's still pushing the envelope. The same envelope. That's the problem.
But he's not wrong. He's not wrong.
I know.
It's like common sense shit. It's common sense. It's like you get these young surveyors, they just get their license. They don't know any better. They're like, oh, wait, here's, I found a cap from 31 to blah, 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 blah. And they're like, I know that guy's been surveying for 40 years. I can measure better than him. I find the point to be, 3/10 over here. Come on. Are you freaking kidding me? That's an embarrassment to the profession. When I see the whole Pincushion thing, I'm just like, oh my God, are you fucking kidding me?
Yeah.
That's an embarrassment. It's an embarrassment to what we do.
The last image that Jerry just jumped off, but he finished his slide with the almost the same exact image that Jeff Lucas started with. The same 4 monuments within a couple of tens apart. 3 iron pipes, a plastic cap. Go for it, Andrew. I don't know if Pete or Pat, did you want to jump in? You've been unmuted, so did you want to jump in on anything?
Well, I just wondering, when you find all these a pincushion effect, why when you leave are there still multiple irons in the ground?
Yeah, what do you do with it? What do you do with it?
Yeah.
Well, in my experience, they're not there when I leave.
Well, so you pull the monuments?
I get locations on them, and there's only 1 monument left. Yeah.
Well, I that's a whole nother story.
That's true, but whose iron is it?
Yeah.
There's no record. Yeah. There's no cap on it.
Yeah.
Yeah.
If they're not proud enough to put a cap on it.
Yeah.
Yeah.
That's a really good
locations. Point. I got the locations nailed down.
Yeah.
And when I put it in there, it's a big ass monument.
Pat, that's a really good point. That's a really good
It's
point.
about it's about 5-inch square concrete with a brass cap, and a little cheap piece of rebar is gone.
Yeah.
Have a location if we ever need it.
Yeah.
You know,
But Trent, hopefully, I think you would agree, you know, like when you bring these new surveyors on board, and you don't have, let's just face it, you know, you don't have 40 hours to mentor them the first time they go out in the field, right? And it's like the one thing I tell my guys before anything else, like if you go out there and you're instructed to search for a monument and set a monument if it's missing, if you find another monument within 5/10 of where the calc point is, shoot the monument. Do not reset it. Don't set a monument there. Like the example that I gave to you, as far as like I found a corner on top of an electric box, right? Because that person on that survey crew, he's essentially a point staker. He goes out there and he's like, calibrate to this, stake this, right? He's only doing his job. He doesn't know what he doesn't know, right? So he goes and sets a corner on top of an electrical box. I mean, come on. And the surveyor who's in responsible charge for that, I know incredibly well. He would never have that person do that exact same thing.
Right. This is our mentoring device right now. Call us.
Yeah.
Just call us. We'll walk you through it, right? And so the cell phone is now our mentoring device, unfortunately. But
I should say that probably 99% of the surveys I made were untouched by anyone else. It was GLO, and then I was in there.
Yeah.
When I worked in Lower Michigan, there was a lot of county surveyors from turn of the century. And then you get subsequent guys. We had records going back to 1909 Fargo surveys when they were doing hydro stuff along the rivers. And we absolutely knew we had the Fargo monument, which was a perpetuation of the original. And here's these other irons. We're not going to use them.
Yeah.
We have a little bit of, I guess, a tighter ship up here. Our monuments, they're all stamped with your permit number.
So's ours.
Ours are supposed to be. You know,
Yeah.
but if they, like Pat said earlier, if he didn't necessarily have confidence in what he was doing, he wasn't setting a cap, or he wasn't doing a final, record of survey or an official survey or an official plat, whatever.
What good is that doing anybody though?
Yeah. Well, he got paid $1,500 or $800, right?
Yeah.
He didn't charge the $2,500 or $3,500 to do it right. So
that's
another topic too. Go for it, Andrew.
What they're saying is that little iron of theirs is representing the east quarter corner of a section.
Yeah.
And so is mine.
Maybe.
They're one and the same, and there's only one mine.
Yeah.
We also have, and this gets to what Kent is saying, we have standards. Like I have to tie to my own work 1 to 7,500, which is pretty loose nowadays. I have to tie to other people's work 1 to 5,000, which is pretty loose. So if I find a monument, within a deck, pardon me, metric system, within 10 cents, I'm happy,
Yes.
Yeah.
Yes.
And wow. And there's no need for me to even pull out the sledgehammer. Thank God, because I'm an old man now. I hate sledgehammer.
Right.
And it's all spelled out in legislation. We have a hierarchy of evidence up here my students are crucifying me if I get it wrong, so I'm not even going to repeat it. But there's 4 steps. You've got to follow the hierarchy. And if you think setting your new monument is the way to go, man, you've missed those 4 steps right there, because there's so much to do before you get that sledgehammer out of the truck. Your shovel.
Andrew, I totally agree, man. And there's still quite a few people on the stream here. I would love to hear what they think about this. Is anybody willing to speak up?
I have a completely unrelated question, but related.
Go for it. Josh is in Georgia, for those of
I'm a colonial boy. What can I say? But I'm somehow roped into a client that does pipelines that has a bunch of stuff in Illinois. So I'm reviewing some parcel maps for exhibits, and the surveyor's not actually surveying any of the sections. He's just using record information. So we called him on it, and he goes, well, I just said, well, I need you to certify your corners were surveyed. And he goes, well, we don't do that. We're just going to say record information. And I'm like, well, then you're not surveying it. So I go, we're trying to buy easement rights. I kind of want it tied to the sections and be actually correct. Is that normal practice in sectionalized lands, that we're just going to take the information that someone gives us and say it's good without verifying it or checking it?
No.
Because I was involved with this company in Georgia, and I got them fired because of the same thing. They were taking GIS info, creating exhibit maps, and saying it's good. In an 8-mile stretch of pipeline, they set 3 freaking control points and said they did a good job. And I had to come back behind them at their cost, because I'm a dipshit, and resolve it, because I warned the client that when you hire them, this is what you're going to get. They're a nationwide pipeline company. They don't give a shit. They have 50 stamps. They stamp what's in front of them. I laid out all the issues, and lo and behold, the engineers called and said, hey, remember what you told us? I'm like, yeah. They're like, well, remember you said you'd fix it for their pricing? I'm like, I don't remember that. But what the hell? I like a challenge. Now I'm in Illinois dealing with the same freaking company going, y'all didn't learn anything.
Yeah. Lucas wrote a book on Illinois' boundary law. Maybe you could send him that.
Well, they already made me rewrite their survey standards, which was interesting endeavor. But I ended up pissing off all their contractors because I made them accountable for what they're submitting.
Right.
I mean, a simple thing is put a coordinate on a POB, POC. Well, we don't trust our coordinates. Well, I don't trust your map then. I'm missing something.
So frustrating.
Love it. Peter, did you have more to add to that? You're going crazy.
Oh, no, he just was talking about anybody else that was willing to share. I had great mentors. I still, now I'm in a position of, where people work for me, I work for the state, and we don't be, like you said, Trent, the government can spend the money, and we do not send one person out in the field. And that is a conscious choice that we make. And at this point, we have enough new people coming in. We don't send a non-PLS out in the field. We do, we send a LSIT with a PLS. We always send a PLS in the field. And I'm working in contracting now, and I contract out the state subdivisions for the state of Alaska before the land gets sold. And we encounter a lot of crazy problems, BLM surveys versus state of Alaska surveys. We have our own rules because the BLM does 2-mile monumentation and gives the state of Alaska a tract of like 15 townships without surveying any of the interior of it. So we made our own rules, and so you have to know that, and you have to know there's a lot of things and people don't know them. I work with a lot of people that come into working in state contracting, and they'll write a proposal that is going to cost 15 times more than my budget because they didn't read the state statutes, and they're going to survey it by the BLM standards. So people don't know. And getting out there and telling them is, and having these conversations and doing this stuff is important. And frankly, all of these horror stories is why I work on the outskirts of surveying. I just switched jobs, and I just put out the request for proposal today to start a real-time network in the state, and that's what I'm doing now. So Alaska is going to have a real-time network that covers the vast majority of the state in the next 3 to 5 years.
That's fantastic. 2 points on that. I think one, most of us on this call that are still left on this call, right, are in this for either mentoring of some sort or helping give back to the profession. That's why we're still on here BSing at the end. And then 2, I think every company would love to be able to put an LS out in the field like you do, but there's just not enough. So, but that's fantastic. And then the RTK, that's fantastic. That'll be awesome, especially to cover the state. That would be something. So, Anybody else want to chime in on some stuff?
When is the next mentoring session?
It should be, I'll try to do it the first. I don't have anybody set up, but I was going to try to either do January 3rd. I may skip that one and just go to January 10th, but we'll see. The first or second, we're just going to take those couple weeks off during Christmas while everybody's on vacation and that kind of stuff. So, but
okay.
The third, I don't know about the third. It may not be well attended. Everybody getting back to work, so I may just push it off till the 10th. So we'll see. Yes. But yeah, there was a great. Well, this is week 58, so it's been nice. A lot of dedication between the speakers and getting everybody involved. So,
hey,
these original ones always create a lot of interest.
Oh yeah, for sure. Exactly. Go for it, Kent.
I just want to say, man, and I know we've been friends for a bit now. You've done a tremendous job in Mentoring Mondays, and anybody that ever comes on here, hopefully you're sharing it with your coworkers, everybody you know. It is a unbelievable opportunity for people to engage with the profession and just hear different perspectives. I mean, there's no clear-cut answer to anything as it appears. And this is such an amazing platform that you've created.
Exactly.
And I just can't say enough. I'm proud to be your friend. I'm proud of everything you've done. And I just can't wait for 2022.
And I do get quite a few emails of just people all across the country almost saying, this is the only way I get mentoring pretty much, and so that kind of stuff. I get there's a guy in Hawaii, same thing. He's like, I only watch it because this is the only mentoring I can get. And so, it's good. So the views, obviously Monday nights are busy, but the viewing afterwards is still decent. And so there's some of them that had almost 1,200 views on YouTube already. So, but they average anywhere between, depending on the topic, between 50 to 100. There's some as many as 400 or 500 on there, depending on what the topic was. So it's still good. We don't get the attendance that we want every single night, but Mondays are tough. I get it. So
a couple of funnies before my battery craps out. I've got a property in British Columbia, and I back on a Crown land. So it's me and the government. And my driveway was cut by others and is on Crown land. Oops. 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 And my water line, when I was working up North Alberta in the summer, my buddy cut the water line and it dog legs onto Crown land and then into my house.
Oh my gosh.
Oh my God. Yeah. Hopefully the scars heal before Google Earth. Oh, I don't want to battle the Crown of British Columbia. I really don't. But, the irony, eh? Oh, the irony.
Yes, exactly. Bernardo, in the chat, you talk about boundary law and real principles. So that is something we can definitely work on. And then also, I'm part of the Western Federation of Professional Surveyors board as well. And we just created a video series that went through the whole syllabus of the NCES exam. And so you can kind of follow through Dane's, we used Dane Corville's surveying manual to go as part of our video series for that. And then there's a few videos from Canoe that kind of finish all of that off. It's for you being on the East Coast, I think it might be $299. If we were part of the West Coast, I think it's like $199 if you're like a Westford member. So not super expensive, but it's definitely a really good video. And then Dane goes through his entire manual. But I will definitely get you topics related to that, and I'll work on those for you. So that's awesome. Anybody else got anything?
No, very good. Thank you.
Of course. Thanks, Pat.
Yeah.
All right, guys. Have a good Christmas holiday. Have a good New Year's. Safe New Year's.
Merry Christmas.
What's up, Megan? How are you?
Hi, Trent. I already took the shirt off and I was wearing my Diamondback Lancer Day shirts today.
Ah.
For curling. She wears it for curling all the time.
I love it.
I get lots of compliments. We're like, what's that?
Love it. All right, guys. Have a good holiday.
Trent.
Go for it.
You got to sponsor a curling team.
10-4. the one going to the Olympics, I hope.
All right, buddy. Take care, man.
Have a good night.
Let's say, guys.
Bye.